Okay, a brief introduction by our side, if we are registering. Okay. Yeah. So I really would like to thank you, Cornelius Witt and Lorena Marciano, for having joined us in this webinar. We, as Italian Institute for Privacy and Archimedes Solution, we are partners of the NGIoT project, a new generation IoT, which is funded by the European Commission, and we organized several webinars about many topics. And this one is one of the most interesting ones because right now there's a lot of uncertainty about the consequences of Schrems II. So let's see if a code of conduct could solve. Little spoiler from our side, maybe it can. It's possible that a code of conduct can bypass some of the uncertainties that right now we are feeling about the data transfer over Europe. So I like to leave the floor to Pasquale and Nichino just for a little introduction, and to Cornelius and Lorena. Thank you.
Thank you very much, Francesco, and thank you to all the participants. Welcome back. This is, as you know, a webinar organized by NGIoT in cooperation with our partner for Scope Europe, and you will hear from them, and Lorena from Cisco as well. You will hear, you have all their backgrounds and bios on the NGIoT website. I will share immediately after my introduction in the chat the link so that you have all the information available there. Why within NGIoT we are organizing this webinar, and not only within NGIoT, I would say, but also within the framework of the activities that we as different partners of NGIoT project do. For instance, myself, I work at Archimedes Solutions, an SME based in Switzerland. We work a lot on certification and data protection certification. We have we are partner in one of the largest output of a European research project, which is the Euro Privacy certification. You can find information on europrivacy.com, and that is a possible solution to some of the issues which are raising concerning data privacy. Now, we all know, as Francesco recently anticipated, that Schrems II indicates clearly that for the European Union, data protection has to be taken seriously. So we are investigating what are the different options and solutions with the market relevance, and this is key, I would say, that different people are developing within Europe. And we think that what our guests today are working on developing is highly relevant as well. This is why we really want to look forward to hear from them, because then we are going to process the kind of inputs they're going to give us, not only from a scientific perspective, so the work that we do with NGIoT and all the different LSPs, large-scale pilots financed by the European Commission in the context of the Internet of Things. It's easy to imagine for you why code of conduct, certification, and all different tools are relevant for the IoT world and different IoT stakeholders. So I really look forward to hear in this webinar legal uncertainties after Schrems II. Code of conduct can be the answers, and I'm really looking forward to hear from Cornelius and Lorena. Cornelius, you have the floor. I'm going to share in the chat your bios so that everybody can have a look at that. Thank you.
Yes. Thank you, Francesco and Pascal. I'm just sharing my screen. Just give me a second. Okay, you should be all now seeing my my slides. Thank you for the kind introduction. Happy to be here. And I think you did a good job in kind of introducing the discussion and the presentation we are going to have today. So I'm Cornelius Witt. I work for Scope Europe. We are a Brussels-based monitoring body for codes of conduct, mostly related to GDPR. And we want to focus today about on Schrems II and how codes of conduct as a tool can be one way to to give legal certainty to some organizations relying on third country transfers. And to get going, I just summarized some of the recent headlines and capturing the debate on the Schrems II ruling, which really was a shake-up for the privacy landscape in total. I think it doesn't happen too often that the New York Times reports on a EU privacy issue, which was the case with Schrems II. I'm sure for those that dialed in, all of you are familiar with the ruling, so I want to keep that very brief. In a nutshell, what happened on July 16 was that Privacy Shield was struck down, so the existing data exchange mechanism between the EU and the US was invalidated, and you also had the alternative, the standard contractual clauses that were assessed. They are still valid. However, the ruling imposes very strict obligations on the company relying on FCCs to assess the level of data protection in the recipient country. The analysis of the ruling is still ongoing, and there are still a lot of questions and answers to be asked. One thing which is clear, and I think most experts agree on that, that the ruling really gave increased the legal uncertainties around third country transfers, and this is where we want to kick off today the discussion on codes of conduct under GDPR. To do that, I want to take one step back and not only focus now on third country transfers as a topic, but on codes of conduct under GDPR in general. High level speaking, codes of conduct under GDPR are one way to prove compliance. They are a compliance tool introduced by GDPR, such as other mechanisms, and it's really important to remember they can be used for both. So either for third country transfers as an alternative to SECs, for example, or they can be used as a normal or domestic EU-wide GDPR compliance element. So this differentiation is very important. What we're going to talk about now applies to codes of conduct, no matter if they are third country transfer tool or a normal EU-wide compliance tool. The EDPB defines codes of conduct as accountability tools which set out specific data protection rules for categories of controllers and processors. The goal of a code of conduct is to concretize the very vague and very high-level provisions of GDPR for one specific sector, and with that create legal uncertainty for the companies in the sector. So what that means in practice is that a code of conduct is always something that a group of companies or organizations of the same sector develop together. So it's not something a company or an organization can do by themselves. It's always a collective action. And then this group of companies or organizations, they choose one or several topics where this market really struggles with the GDPR implementation, and then really make clear how they address the GDPR requirements in their sector. And that is one of the key advantages of codes of conduct in general, that they have the sector specific requirement, which means you have in general the very vague and high level principles of GDPR, and then a code of conduct comes in and really narrows that down for an individual sector. So a code of conduct, in the end, you can think about it, is a rule book for companies that adhere to this code, which really specifies and concretizes the legal requirements of GDPR for their sector. So why would companies do that? Because GDPR itself gives several incentives and benefits to do so. You can prove compliance with it. A code of conduct, there is an official approval process by the European Data Protection Board, which means a code of conduct is under GDPR is a lot more than only a self-regulatory tool where you as companies say, okay, we're going to have now this code and it's going to be fine, everybody should believe us. No, it's really a co-regulatory scheme And once a code of conduct is developed, there is this official approval process by the EDPB, which then officially approves and endorses this code. We'll go into more detail later on, but this is a key element that everybody should keep in mind. When you adhere to an approved code, this automatically then has legal benefits when it comes to proving elements of compliance. So the risk of getting fined or being sued is reduced dramatically, but also on a more practical level, adherence to a code of conduct really gives you as a company a market advantage, as you can enable trust in your products or services that are subject to a code of conduct. We heard from different players we develop codes with that they often, when they are in customer negotiations and there are questions about privacy programs, etc., it comes in quite handy for them to say to their potential customers during the negotiation phase, look, here's this code of conduct which we adhere to. You can transparently understand how we implement GDPR requirements. Also, more practical element and benefit is the codes of conduct also really reduce compliance costs. So it's in general a bit more sustainable strategy than some other solutions that you can take. And it really establishes best practice rules for one sector. So with the code of conduct as a company, you're not out there alone with your GDPR implementation, but you have a collective standard in the market. Codes are highly versatile, and this is another key advantage how the codes of conduct are introduced under GDPR by the regulator, is that the bodies, so the companies that develop a code, they can themselves really choose its content and its scope. A code always must cater the specific needs of a sector, and by that facilitate the effective application of GDPR. But there is no general rule how broad or how narrow a code of conduct has to be. So it's really up to the companies to identify a problem with GDPR implementation in their sector, and then offering a solution with the code of conduct. There are examples of broader codes. Lorena will go into the EU Cloud Code of Conduct later, where you have where you capture with the code more or less entire sector, as all cloud service providers, they act as a processor. So we define in that code of conduct Article 28 GDPR, the processor requirements. But the code can be also very narrow. So you could say in our market, only this one particular aspect, for example, only data retention period in our specific sector is not clear how to deal with that, when we should delete the data. So you can just address that in a code of conduct and leave all other GDPR related question out of the scope. The EDPB guidelines, they say that a code needs to provide sufficient added value, and with that you are good to go in a way. So you identify an existing problem in the GDPR implementation in your market, and then you offer a solution with the code. Another key requirement addresses that the code has to be understandable and transparent to other players in the ecosystem. So a code should not only benefit the companies that develop this code, it should be also transparent and understandable for customers, for key stakeholders, maybe data subjects, data protection authorities, to really understand what the code is all about. And lastly, I want to shed light on the roles of small and medium-sized companies, as this is a hard requirement by GDPR, directly manifested in Article 40, that a code of conduct has to address the specific needs of small and medium-sized enterprises. So a code of conduct has to be open for those smaller players, and with that, codes are in general a bit of a leaner framework compared to other compliance solutions. One element I want to discuss with codes of conduct, and it's really kind of for codes the other side of the coin, if you want, is the monitoring. So a code of conduct established under GDPR always has to have a monitoring body in place. you can think about a code of conduct that there are three main players that you have to think of. One is the companies, organizations that actually develop the code. Then you have two, the data protection authorities. They approve the code and regulate everything about the approval process. And then you have the monitoring body, which is a third party, which is overseeing the compliance of those companies under a code of conduct. This compliance oversight follows certain requirements by GDPR. So the development of a monitoring concept has to be independent. So it has to be ensured that there is no direct conflict of interest between the companies that develop a code of conduct and the oversight body, to ensure that it's objective and that it's a fair process when verifying the compliance. You have to provide, as a monitoring body, expertise in the subject matter. This is a bit of a no-brainer. Means basically that the people working at the monitoring body and assessing the compliance of the companies, they really have to make sure that these people are experts in the subject matter and that they know about GDPR and they also know about the sector that they are verifying the compliance to. Monitoring has to be active and regular. This means that a code of conduct is verified on an ongoing basis. It's not enough to check compliance once and then you're good forever. No, there has to be an ongoing scrutiny of the companies. And lastly, there have to be established procedures and structures in place, including complaints handling. The idea there is that, for example, if a company which adheres to a code of conduct and you would be a customer of that company and you would have evidence that there is an infringement of the code, that something is not going on correctly, you should be able to file a complaint directly at the monitoring body as a third party to look into that. Having said that, we now understand a bit better the scope a code of conduct can have, the key principles, and also what the monitoring is all about. And with that, I want to shift back to the first discussion and the first slide we had, coming back to this possibility that a code of conduct can be a tool for third country data transfers. Under GDPR, there are in general 5 ways that organizations can safeguard their exports of data outside of the EU. Codes of conduct are one of them. Everything we discussed so far applies for third country data transfer codes. And you also have the relevance of the monitoring body, which I just explained, which is in that sense quite important, because when you read the Schrems II ruling, a lot of criticism and the findings there, they go into the direction that there is a lack of enforcement and that it's just, you know, a safeguard on paper, but it's not really checked if there is compliance to the tools. And there, I think code of conduct can play a very important role with this third-party monitoring body in place. Just a brief look at the other tools that are there in GDPR to safeguard third-country data transfers and also compare to codes of conduct. So you have the adequacy decisions. This means the European Commission identifies that a third country ensures an adequate level of protection. Then you can safely transfer the data there. The problem is this adequacy is only there for around, I think, a dozen or so countries globally. So it's not a global tool for data transfers. And there's also nothing really a company can do to change that. You have the standard data protection clauses, or also more known as under their old name, the standard contractual clauses, SCCs. They were also, as I mentioned in the beginning, assessed by the ECJ in the Schrems II ruling. We are now still relying on the old set, like the pre-GDPR one, SCCs. They are supposed to be updated quite soon. It will be interesting how the criticism of the judge in the Schrems II ruling will be addressed in the new set of SCCs. One thing which differentiates them a bit from codes of conduct, which is important, is that SCCs always follow a one size fits all scheme. So it means you have one set of SCCs, and they apply no matter what your company is doing and in which market you operate. They are not sector specific, such as codes. Concluding, there are also binding corporate rules. They are can be developed by one company themselves, which is a good tool for them, but it's not it cannot become a market standard like codes of conduct or other tools. And this is also quite burdensome on the company. So usually BCRs are a valuable option for larger organizations with more in-house expertise, but not for smaller companies or SMEs or startups. Certification mechanism is another safeguard to transfer third country data. I think it's the closest tool to codes of conduct. In general, codes are a bit leaner in their overall framework, and also for certification mechanisms, the regulatory setup is a bit more complex because you not only have the data protection authorities, but you also have national accreditation bodies that factor in the approval process. With that, I want to draw a quick halfway conclusion before handing over to Lorena for the second part. So we learned the benefits a code of conduct has more on now we learned the theory and the concept behind it. And with that, I think Lorena can now give us a closer look on the actual practical implementation of codes of conduct, and also share some case studies and lessons learned from her experience there, to really give you a better picture how codes of conduct are implemented in the market.
Thank you, Cornelius. Hello, everyone. My name is Lorena Marciano. I am the director for EMEA Privacy at Cisco, and their EMEA Privacy Director. If anything can be reassuring to all of you, and this slide number 6, I think I went through all of this with my company. So I went through all this, except the certification mechanism, I think I went through all of this implementation and what it means for a large organization which has 72,000 employees, and it's actually active in 165 countries. So trying to do this at that scale, it can be quite daunting. And also, if one of the mechanisms goes away, then certainly you need to have a backup plan. So that's why generally as a company, we tend to look at all mechanisms from an implementation standpoint. For us, I heard many times that standard contractual clauses or binding corporate rules are just a check on the box, which is easy to get. And, it just not sign a contract, show a policy, and that's done. I want to assure you that it's not the case. It actually requires a very long implementation for the company to even be able to sign SCCs, or even going through the review process of the binding corporate rules. And the same goes for the adequacy decision, especially the ones that require external certification, like the Privacy Shield was, or the APIC CBPR. They all require a lot of implementation, a lot of scrutiny with external validation in our case. Why am I telling you all of this? Because I guess when we started working on the code of conduct as a company, we started from a point where we knew how hard that was going to be, and how important at the same time is exploring certification mechanism code of conduct. Particularly because the change that you need to make is within your company before you can even start going to the approval process within an authority. So just to go a bit on the next slides, please, Cornelius. The code of conduct that we see now is the result of, I don't know how many, probably hundreds understanding on how do we review and make sure that what we are creating as an industry is actually something that we can all individually live up to it. So one first message that I want to send to everybody is that the code of conduct has required a lot of work. It will require a lot of work. It's not something that you can create in isolation. It's not a certification mechanism you can create within a company and start selling it to someone else. It's something that needs to look like the company that they're going to apply it. And also it needs to be satisfying the requirements of the data protection authorities, which how I will show you, it's a very lengthy process in itself. So it's a lot of work before, just to come up with the code, and it's a lot of work afterwards. Particularly this code of conduct, for some of you, you might remember that they've been around quite a bit. You might remember that in 2014, there was a task force looking after code of conduct for the cloud environment. That had its own start and injection in the GG Connect at the European Commission. And then this code and the work that was done by hundreds of companies at that time was put on hold because we knew GDPR was going to come. So the work was then put on hold and then pick up again in 2017 by the company that you see here up on the screen. So essentially we took the code as it was before pre-GDPR, and then we had to rework it in accordance with the GDPR principles, which, you know, to our own welcome surprise, indeed they encourage companies to actually do code of conduct. Code of conduct, however, that they look different from what we had before. I know a lot of my colleagues here are Italian, so you might remember a lot of the codes that we had under the decree before. They were very nice code, but they were not really created by industry and for the industry. This code and the letter of the GDPR and the guidance that came afterwards are actually telling us that the code needs to be something that is actionable, that is going much further than the GDPR, and it must be easy to read. It must include also the SMEs, because as small and medium enterprises, we need to remember most of the time are the ones that are they don't have a voice that's heard, right? Just because most of the time they tend to negotiate with bigger companies, and therefore they lose bargaining power. And also it needs to be, why it needs to be easy to understand it, because it needs to be enforceable by the data subject. Even if in this code of conduct it's a B2B code, right? Because it's a code that tends to further implement Article 28 of the GDPR, so the relationship between a controller and a processor. On the other hand, it needs to be understandable by the individuals so that they can then enforce it against us and against the controllers themselves, so the customer. So as you can see, this is something that it creates a lot of, has a very high standard. I think Cornelius has said before, this is a rule book. I tend to agree, disagree. It's not a rule book. It is actually a standard that we're setting up in the industry. It's a standard that we need to live up to it. It's a standard that has an external validation by a third body, and it is a standard that has the approval of, in our case, all data protection authorities and the European Commission, because it's a transnational code. As you know, when you are a transnational code, your approval is much longer. It looks a bit like the BCRs, but not quite, right? I thought I had I would say less work to do with the BCR than actually with the code of conduct, if you want to know my experience. In my case, we also got the BCRs at Cisco in 6 months from the submittal. So we actually were, I guess, very good or very lucky. I tend to think that we're very good. But with the code of conduct, I think this is even much more complicated. So what is the code of conduct? Can we go to the next slide, Cornelius, please? So I'll actually go back to one, because I wanted to make a point there. Sorry about that. The one number, yeah. So one of the things I wanted to make clear again and reinforce is that the company that you see here are the members of the code, and the one actually working on it, continuously working on it. But more importantly of this code is the role that Scope is playing in this case, which is the monitoring body, which means that they themselves, they're going through their own approval process with the data protection authorities, especially the Belgian one, because it's our lead authority, and they will need to get certified that they're able, essentially, to keep us on our feet when this code of conduct will become approved. And that is very, very important, because it's one of the elements that is changing versus the standard contractual clauses or the binding corporate rules or anything else. Is the continuous monitoring that we as companies that we adhere to this code, we receive, meaning that there will always be an external party that will certify us at the beginning, but will continue to make sure, it will be their role, to make sure that we continue to abide by the letter of the code. Then in itself is very important. It's very important because if you look at the case law that we had in the past, the defaults over even of the privacy shield and safe harbor, it was also that there was no an ongoing controls, right? Which it doesn't mean an yearly control, it's an ongoing control, meaning that everything that we do, it's under the eye of the monitoring body. Everything that we do can be claimed from an individual that then can claim to the monitoring body that we're not abide by the rules of the code. So it's continuous, if you like, pressure on the company to make sure that we are doing it right. And I think this is one of the important points that needs to be understood, and it's probably one of the biggest change with the original understanding that we had of code of conduct under the directive. So moving to the next slide, what is it we're going to do with this code of conduct? The code of conduct, as I said, in its original form, which is the one currently under review and final stages of approval with the data protection authorities and the European Commission, is to unveil what Article 28 is actually telling us. So it's providing details on how we're going to protect personal data that our customers are going to entrust us with. So it's providing details on how, how we're making relevant and understandable how we're processing the data, who are we including in the chain of value, so who are the sub-processors that we're going to onboard, and what kind of requirements we need them to abide by, but also what kind of type of assurance can we give versus a sub-processor. What kind of scrutiny do we need to make of the sub-processor? So it's not enough just to sign a contract with one of our vendors. We actually need to prove that we audit them, that we make sure that we're applying the same privacy and security measures before onboarding them, so that the signing a contract, it's actually the last moment, right, where we all feel that this is good and it's going to live up the requirements of the code. Then there is the right of audit, which I hope some of you know, it's probably one of the hardest in terms of negotiating with your customers, because there is a bit of, I would say, not clear understanding on how far the audit can go and how company can actually apply the audit. Also audit of what? Of the personal data, of the data center, of the process. What is really this audit about? Also, who needs to pay for it, or who, can you audit directly the sub-processor, although the customer have no contractual relationship with the sub-processor? So all of these things are things that we have tried to create to a very detailed level. Then obviously the liability, more importantly, the record of processing. What is this record of processing? Is that a big Excel sheet, or can we just make something more, I would say, interesting and telling, right? So what is this regular processing? How do you show the regular processing to your customers? For example, one of the things that we do as a company is that we publish what we call privacy data sheets, which is, if you want, a summary of a record of processing, meaning that we tell exactly the customer what we do with their data, how long we keep it, where do they travel, and so forth. This is something that is also included in this idea of the record of sub-processing. Rights of data subject. How are we going to respond to them? There is a lot of uncertainty in the market, and that is probably due to the lack of guidance that we're receiving from the authorities on what is a good response to a DSR, a data subject access request. What is that we need to give them? Is that a dump of files with their names or information about them, or is actually articulated answers about what we do with the data, how they can delete them if they like? Are we empower them with a dashboard? What is it? It's really right to data subject. One thing that is also very important about this code of conduct is that we actually created the code of conduct, and then we created what we call a control catalog. The control catalog, possibly it's the best piece of this code of conduct, because it maps out the requirements of the code versus the existing requirements under existing certifications. Why are we doing that? Well, because we want to give an understanding of the company that they approach the certification, how far they are from getting the certification. So the code essentially maps out certain ISO, SOC 2, and other C5 and so forth, other certification, and shows what is matched by those certifications. So if as a company you have ISO, you have C5, you might be able to have that already, and what is not included, and therefore as a company you need to work for it, or you need to show evidence that you already have it. So that's a very important piece of the certification itself. Am I forgetting anything, Cornelius? I think no, so maybe we can move to the next slide. Yeah, as I said, this is a journey, right? The journey starts with creating the code. And for us, it took us, I think, 2 years, 500 hours calls. So massive work from all of us before getting to a point where the code was actually good to be submitted for approval. I wanted just to also give you a bit of an idea. I think probably because we are very similar players, so that's why it's good to have codes per industry. It's actually a code that that was easy to some extent to find a common ground. We didn't really have big issues that will stop the work and we were not able to move forward. So as players, I would say, we were all coming from the same struggles, and we were all trying to get through the same solutions. I think obviously the devil's in the details. So some details there was a bit of negotiation, but overall, on how it's structured, on how it's supposed to be done, on how we're going to move forward, on the adherence, on the monitoring body, I thought that we had a very good cooperation. So where are we now? So we submitted to the code, and I think it was more or less 7 months ago or 8 months ago, Cornelius, I think, and yeah, probably the pandemic kind of makes you feel that we either spend only 2 days or like 3 years. So I have a bit, my timing is a bit confused at the moment, but I think it is 8 months ago that we submitted the code for approval with the Belgian Data Protection Authority here in Brussels. Because they are a lead authority, because our monitoring body is indeed funded in Belgium, and so also all the work that has been done. So we are under the supervision of the Belgian Data Protection Authority. They already done the review, and then what happened is that we went to secondary review, which to this stage is very similar to BCRs. So for those of you who went through BCRs, you know how it works. You have 2 lead authorities, 2 co-reviewers that review the code and make additional comments. We went also through that, through all the negotiation that required, right? We received comments back, we had to work them through them. And then now it is with the submission of the DPB, which we already overcome some of that. We're waiting for the opinion of the European Commission for the code then to be approved. So I think in 8 months we made very good progress. I cannot say that it's more, in my experience, is that it is much more, and requires much more work in terms of making sure that we reply to all the data protection authorities. Especially in the last phase, we had comments from different of them. So it's not like the BCRs that you stop it and you just get comments from the DPAs, but there is nothing really for you to do. No, in this case, when you receive the comments, you need to address them, negotiate, and then you move forward to the commission opinion. So a bit more long. Obviously, we're learning as we go, because when I think there is 2 codes that are currently going to approval at transnational level. So we're obviously learning as we go as well. So probably if we talk in a year from now, we will have a better understanding of the process itself. Next, Cornelius, please. Yeah. So Schrems II, right? Yeah, I work, as you know, for a US multinational responsible for EMEA. This Schrems II really came sitting on my desk, and it still is. So there is a lot of, as you've seen, where we are now, we are in a time of uncertainty. Yeah. The uncertainty is due mostly by the decision itself, which is telling but not telling, because the court did its job, right? And then we're still waiting for guidance on the ADPB. And also we're waiting to see the new SECs, which they promised by end of the year, possibly early December. I really hope that Bruno Gencarelli particularly keeps his word, and then we're going to have it in early December. So we are in a time of uncertainty where it seems that anything really works or everything really works. It's the same thing, right? When there is an uncertainty that is covering the entire industry, you feel that there is either issues or non-issues, just because depending on the level of expertise of your customers. I would say I feel there is a lot of issues in that sense. Someone said before in the introduction that the code of conduct might be a place to bypass the Schrems II. I doubt that is possible. I don't see how we can circumvent the decision of the court. However, what the code can be, it can be the game changer, right? For those of you who have been around enough to remember Safe Harbor, one of the things that is continuously being criticized by the European Commission, by the European Court of Justice, is the inability to really listen and protect the rights of people located in the EU, so the rights and their protection of personal data. And why this is always the case is because the measures that we have currently, so the mechanism that we have currently, either are the reflection of a political play or are a tool that can only be used on one-on-ones, right, between a company and another company. So there is nothing in between. There is nothing that can, with a certain level of understanding or a certain level of assurance, can provide rules that can apply to an entire industry, and also rules that are approved by both the data protection authorities and the European Commission. Up until now, we always had the court agreeing with the DPA against something that was done by the European Commission. I think a code, especially a transactional one, that needs to bring everybody together, meaning gathering the opinion of everybody together, can also be much more strong to survive, if you like, the test of time that we have. When it comes to privacy, right? When it comes to privacy itself, so the ability to protect personal data wherever they flow across a multinational or across an industry. So that's why we feel that the code of conduct can be this type of exercise, because it will be the first of a kind. It will bring together multiple, I would say, polarized point of view, and at the same time can also make sure that, because of that third-party oversight, can make sure that the companies abide by these requirements, which can be both technical and organizational one, in the same way that the ADPB has already indicated to it. Where we are right now, right, in terms of this type of work, we're just going through the code. The code itself already has some elements of transfer mechanism. We need to work through them and see what else we need to include to make sure that the code can bring that level of uncertainty, the level of certainty that this situation has created, particularly when it comes to protecting individual rights in a country that it's not providing the same level of protection, as well as what kind of technical measures are we recommending for the company to include, and that needs to work for the entire industry. So this is the things that we are looking at. In terms of organizational measures, it can be as simple as, well, simple. If you have it as a company, it will be simple, but if you don't, then you need to work on it. But such as handling with a due care any type of access request from governments, the ability to provide transparency on how you're handling them, and how to what extent are you notifying people and customers, and then what kind of technical measures can you put in place in terms of techniques that we've been talking about for a while, but nobody really see them in place, such as a much higher level of anonymization and pseudonymization technique, as well as creating a level of cryptography that right now it's not guaranteed for everybody. So those are the things that we are looking into. and we're bringing onto the table also by discussing with the authorities themselves. The code is already going through review, so we need to, any change that we're now making for the third party, for the third country transfer needs to be approved by the DPA even before we include it in the code, which is good guidance for us. So we know, okay, how far we can go, and we get also an insight of what the new guidelines will look like, and they're coming in hopefully by November from the DPB. So that is a bit to give you an idea on why we think this is a good tool and how we're working through it. Can we go to the next slides, Cornelius? Yeah. So what's ahead of us, right? We said what we hope as companies that work through this code is that we will get the approvals and probably come back to you and tell you how it was from beginning to end. A code that indeed will bring together forces that before were all working independently to some extent. We're also hoping that we're gonna create the module, then to get it approved at a speed, at much speed, with a bit more speed than we have it up until now. And more importantly, what we aim to see is that we can introduce a new concept of code of conduct to become really a standard for the industry that then will possibly encourage other industries to do the same, because what is needed for the cloud providers is also needed for the financial institutions, as well as for the telco, as well as the advertising and so forth. We hope that this type of work will inspire, other industry where we see that there is a much more needed of, and this clear rules, clear oversight, clear commitment to privacy. With that, I don't know, Cornelius, if there is anything else you want to add.
No, thanks, Lorena. I think that was perfect, on point. And yes, I think I can hand over again to our host and moderator, Pascal.
Thank you very much, Cornelius, and thank you very much, Lorena, for this very rich presentation, which, I mean, personally has stimulated a lot of thoughts and questions for me. I'm personally involved, for instance, in some health data projects, and I was thinking how the health industry could work on this, because for sure there are players, thinking about that. But I don't want to abuse my position as moderator, so I want to throw the ball back to the floor to see if there are questions from there. Otherwise, I will ask you myself a question. So unmute yourself if you want to ask a question and introduce yourself to our guests.
And don't be shy, possibly.
Now, if not, I was thinking this. One could perceive the, let me use this word, the fatigue of going through this process. I have worked myself on, on drafting and creating on a certification scheme, and certainly there is fatigue there. Now, my question is, you explained very clearly the legal issues there, but as we all know, when you do work, there are legal issues, and then there are business, and there are also, kind of personal issues, communication issues. So my feeling is that, the first slide that you showed, that the many logos of different companies. So the issue is when you do the work on a code of conduct, which has the specificities that you mentioned, the legal specificities when you have to create it. From where do you start with the stakeholders, and from which stakeholders do you start in order to get the people on board? Because in every vertical and in every industry there are different kind of players. So who do you want to be sure that you have on board first in order for the others to jump the bandwagon? I think that probably was an important issue that you had to deal with. It's for both of you, the question. So.
You want to go first, Cornelius? Go.
Yes, no, thanks. It's a very relevant and interesting question, I believe, and I'm happy for Lorena to share more her perspective from the industry. We as a monitoring body who work on different codes of conduct, one thing that we always realize, which is a key requirement, is that you really have to have the willingness from the organizations to really participate, because a code of conduct, it really is, it's a bit two sides of the same coin. The key advantage is that companies can in the end develop a compliance tools by themselves, and this kind of interpretational power you usually don't have that often. On the other hand, this then obviously requires a lot of resources and manpowers and expertise from the companies, which make it difficult. And as you said, through a lengthy process, you have to jump over a lot of hurdles, which then can lead to certain fatigue, as you described it. What we also did, besides or try to do on an ongoing basis, besides really the buy-in from the organizations themselves, we try to consult with key stakeholders, which in a way that it makes most sense for the current project in a way. For example, with the EU Cloud Code of Conduct, that's a code focusing on the business-to-business environment. So and it's quite complex with the requirements for cloud service providers. So it's not something which you get a lot of great feedback if you only have asked like data subjects. But there, for example, we chose to be consulted by Peter Schaar, the former head of the German DPA, who obviously has a lot of expertise in subject matter and can really bring in the key concepts from a DPA point of view. But he himself is not in office anymore, which also then solves the problem of being the regulator at the same time, which would make it impossible to ask then. So why I'm telling you this is that when you asked about which stakeholders to consult, I think it's really a tailor-made approach which really has to make sense for each individual code of conduct process, and there you have to identify the players that are most relevant and will give you the best feedback to really improve the quality.
And in terms of like a legal drafting technique, okay, do you engage the stakeholders already with some draft ideas, or you first collect inputs from them, and then you process their inputs, and then you start the drafting? I mean, which process did you follow? I mean, did you already have some ideas in mind and you proposed those ideas to them, or you first collected the inputs from them?
Yeah, so here again, in general, I would not say that there's a golden rule and there's no blueprint how to do it. In our case with the Cloud Code of Conduct, we really already established a very robust draft of the code itself. As Lorena mentioned, it came out the Cloud Select Industry Group from the European Commission. So there was also more stakeholders involved. I think the Working Party 29 back in the day also already provided feedback on that. So I think it's the best way to do it is really an ongoing process, and that you have the different stakeholders as sparring partners in a way to really ongoing contribute to the overall work.
So just one final question, maybe to Lorena on the more kind of legal side, probably. So now we all know that when data protection compliance is at stake, you go to the CEO of a company and they don't get it until when you say you are going to get sanctioned if you don't do this, this, and that. Now, when you propose to a CEO of a company to invest money with other companies for the creation of a code of conduct, which kind of a reaction do you get there? Is this understood at that level, or you have to do a kind of other kind of engagement? What was your experience with that?
Well, I think I've been lucky because I have a CEO that went publicly and said that privacy for him is a fundamental right, and he will do everything to protect it. So in that sense, and he put the effort and the team behind it. So in that sense, I think I think we have a very good buy-in. Generally, also as a company, we tend to explore any possible ways that will make our customer feel more at ease with us. So generally speaking, any type of effort that obviously needs to be substantiated with a scope and an ability to achieve, right? It's always very well welcomed. It's something that we're willing to spend into. So in that sense, it's really, so I think you need to embark on this type of journey if you have a company that has that culture of making sure that we do what is most important for people to trust us, to keep us a trustable company, and also to make sure that everybody that uses our technology feels that that technology has been built with that ideas. We have, especially during the pandemic, one of our tools I think has been used at an exponential level. And so people should always feel that what we're doing is actually something that they can feel comfortable with, no?
Yeah.
And to that extent, I think even the pandemic, if anything, has showed us and has showed him that investment that he put in privacy and security did pay back. In a moment where many companies were criticized, I think we had the ability to show that we were doing the utmost. So to that extent, I feel that that he gets it, we get it, and it's all it will only get better.
No, so we can understand that either you are lucky, but you're also very good in your job, probably. So I think it's a combination of both things. So it's 11:32, and our hour is gone. I want to thank both of you. If our colleagues from Istituto Italiano Privacy want to say a final thank and a final goodbye, either Alice or Francesco, I want to invite them to salute all of our contributors and guests. Yes, Alice.
Yeah.
So Alice, I give you the floor to conclude our webinar and to thank our participants and guests, which I thank personally for their contribution. I just want to say that the registration of this webinar will be uploaded immediately after the post-production phase from our project comms on the NGIoT website. Will be disseminated to our social media, and probably also Cornelius through their social media, they will disseminate it. Alice, you have the final word.
Okay, so thank you, Pasquale, and thank you very much, Cornelius and Lorena, for having shared with us your work. It has been a super interesting hour, so we hope that there will be another opportunities in order to share your ongoing works, because I'm really interested into the developments on this code of conduct. So thank you very much, and I also thank you all the public that have been with us this morning, and we hope to contribute again another time. So thank you to you, and have a nice day.
Bye bye.
Thank you. Thanks for having us and organizing.
Yeah, thank you.
Bye bye.